Any mention?
My lord, item number 7, I'm praying for a week time, my lord. Item number 7.
Why?
My lord, inadvertently, my lord, the brief is not with me now. Or it may come after 3 days. After 3 days, my lord, any available.
You are for the appellant.
Yes, Lordship.
You are ready.
Yes, Lordship.
See, because if I
Yes,
remember
yes.
correct, this
yes,
matter
yes.
has already been
It's
heard,
my turn now, my lord.
but we still have to get him to refresh.
Yes.
You have to refresh the court on.
Yes, Your Lordship.
What we can do is we'll allow him to at least refresh the court on some
My lord,
facts.
my lord.
Then you can reply.
My lord, my
But
lord.
we'll have the matter fixed for your reply on Wednesday. I think Wednesday we're having this court.
Yes.
We can't go on because the
My lord.
matter half heard, then it goes into
Exactly.
goes into oblivion.
Exactly, my lord.
Everyone forgets.
My lord.
So we'll allow
Let
him
it-
to start. We'll see.
My lord.
May I please, Your Lordships? I beg to mention item number 13, Your Lordship. This matter comes up after 4 weeks, Your Lordship,
Why?
as the conducting counsel is out of station, Your Lordship.
Item number 13.
Yes, Your Lordship.
Mr. Manta, you are there in this case.
No, I'm being assisted by
M1 Sweat, Your Lordship.
M1 Street. He is out of station. Because the paperwork, I have to go through that. Okay. It's a very
Why
new
4
case.
weeks?
2 weeks or so. 2 weeks.
On premier with the appellant, this is matter to 2 weeks.
So much.
Please, Lordships, I beg to mention item number 9.
In number 9, Your Lordship, the appellant was supposed to have gone for treatment to Nagrams.
Your Lordship, he has surrendered. The treatment is done and he has returned on the 8th. Your Lordship, he has surrendered.
He's now in
Surrendered.
custody.
Yes, Your Lordship.
Okay. So that report will be there, most probably.
We haven't received any report.
But the jail authorities
We'll get that from them.
should have a final report.
Yes, we'll ask them to give us the report.
Otherwise, we'll take the submission of the council on record.
Okay.
But why are you asking for time?
Your Lordship, for hearing, Your Lordship. This one is fixed for hearing, Your
Yes,
Lordship.
it's for hearing. Why are you asking for time? You are there.
Personal difficulty of the conducting counsel, Your Lordship, today.
On premier with the appellant, this is matter of 2 weeks.
Pleasure, Your Lordship.
May it please your lordship, I beg to mention item number E. The conducting counsel is not well. Kindly list the matter after 2 weeks. Yes, sir. Item number 8.
On premier with the appellant, this is matter of 2 weeks.
Much obliged, your lordship.
What happened?
May it please Your Lordship, I beg to mention item number 12. I pray Your Lordship to seek 3 weeks' time.
On premier with the appellant, this is matter of 3 weeks.
Obliged, Your Lordship.
Release item number 1.
My lord, this is the application seeking leave to appeal, my lord. When the applicant is the legal representative of the victim, my lord,
Oh, okay.
as well as the informant, my lord. So, my lord,
There's an objection, my lord. I filed an objection of maintainability, my lord.
Yes, yes.
Yes,
We recall that.
my lord.
Yeah,
Yes.
made it.
So, my lord, if my
You are the
I'm
you are the acquitted.
yes, my lord. I am the accused person, my lord. My lord, my only objection to this is, my lord, she has invoked section 378, subsection 4, my lord. Now, in order to bring home to satisfy section 378, my lord, there must be two things, my lord. The first thing, my lord, this acquittal must have been come because of a complaint, my lord. Number one. The second part, my lord. And
378.
section 370, yes, my lord. My lord, may I read section 378, my lord, if my lords have got, my lord. Section 378, my lord. Safe as otherwise provided in subsection 2 and subject to the provisions of subsection 3 and 5, my lord. So we'll skip these points, my lord, and then we will come to subsection 4, my lord. If such an order, my lord, has got it.
Yes.
If such an order of acquittal is passed in any case instituted upon complaint, just mark that complaint, my lord, complaint and the High Court, on application made to it by the complainant in this behalf grants special leave to appeal from the order of acquittal, the complainant may present such an appeal to the High Court. Number 5, my lord, is also relevant. No application under subsection 4 for grant of special leave to appeal from an order of an acquittal shall be entertained by the High Court after the expiry of 6 months where the complainant is a public servant, and 60 days in every other case computed from the date of that order of acquittal, my lord. So, my lord, the two conditions must be satisfied for invoking section 378. Number one is that the case which ended in acquittal has been instituted on a complaint. Number one. Number two is, my lord, the complainant himself comes before the appellate court, my lord, or before the High Court for invoking, my lord. Only on these these grounds are satisfied, then, my lord, they can invoke section 370. Now, no LRs, my lord, no legal heirs can invoke these provisions, my lord. So that my only objection is to that point, my lord. The victim or not victim, that is a different issue, my lord. I've checked that also. But strictly speaking, on section 378, my lord, no other than the complainant himself, my lord, can seek a special leave of appeal. That also within 60 days, my lord. Now, even if the complainant dies, my lord, under these provisions, my lord, the legal heirs cannot be substituted, my lord.
So, see, that is falling back on the general principle of criminal jurisprudence.
My lord.
Once the matter, once the principal, subject dies,
yes,
so matter dies with him. Wow.
My lord.
my lord, if I may humbly submit, my lord, I must concede, my lord, this has been filed in the wrong section, my lord. It has to be, my lord, under section 372, my lord. 372, the victim has been defined, my lord, in section 2 W, my lord, where the legal heirs or the guardians are included, my lord.
So my objection is also only on this point, my lord. 372, my lord, that's a different issue, my lord.
Whatever the case may be.
Yes, my lord.
See, citing a wrong provision would not invalidate the
My
petition
lord,
as such.
yes, that is there. But my lord, this must give a power. My lord, now it is not merely citing a wrong section, my lord. It is giving power to somebody, my lord. It gives only to the complainant, my lord.
No, that's
Now the
true.
complainant,
Exactly. See,
yes,
that is the whole purport of the
yes,
the section cited.
yes.
has certain,
Yes.
qualifications,
Yes.
and the applicant here says
Yes.
that perhaps that is the wrong.
Then
provision,
then let them withdraw.
Then they are
Yes.
resorting back to another provision.
Let them
For
withdraw,
example,
my lord. I
370.
have no objection to that, my lord.
My lord, this is a legal aid case, my lord. And my lord,
Legal aid
it may
case
be
also,
treated as a appeal under 372, my lord.
See, Miss Datta, it may be legal aid.
My,
What is legal aid? It is only for an indigent person who
My
cannot
lord, my
afford proper legal counsel, then he will be given legal counsel. See, to that extent, that is legal aid. But doesn't mean because it is legal aid, anything can be considered under the sun. That cannot be.
no, my lord, I'm not.
Provisions has to be followed.
Yes, my lord.
If you are found amiss, then that's it.
If they come under proper provisions, my lord, I have from day one I said it, I have no objection, but I only have
Lordship,
objection on
allow
this.
me, my lord. I can correct it, my lord.
And the question of okay, let's try. We are not conceding, but let's read 372. What does it say?
My lord, 372.
372. Section 372.
378. Yeah, 378, baby.
That's what I mean.
May read,
See,
my
we'll have to check whether 372 gives the
My lord.
power
May read, my lord.
to the legal heirs. This is a case of legal heir, isn't it?
My lord.
Yes.
Or the legal representative
The sister of the victim, my lord.
victim.
My lord. It's a legal heir, my lord. May I read, my lord, 372, my lord. Section 372.
Yes.
No appeal
Shall I?
No appeal to lie unless otherwise provided, my lord. No appeal shall lie from any judgment or order of a criminal court except as provided for by this code or by any other law or for the time being in force. My lord, the proviso is important, my lord. Provided that the victim shall have the right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offence or imposing inadequate compensation, and such appeal shall lie to the court to which the appeal ordinarily lies against the order of conviction of such court, my lord. My lord, may kindly come to section 2, my lord, where the definition of victim is there, my lord. Section 2, subclause, my lord, WA, my lord, which is inserted.
No, it's inside the file.
Section 2. Oh,
No, it's not this one. It's not the one.
Section 2.
WA, my lord.
Go.
Victim means a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir.
I think Mr. Yogin, this settles it. In any case,
My lord,
you see, in any case,
even if they invoke section 372, my lord, then I will have an objection, my lord. Why? Because where is the legal heir certificate, my lord? Anybody can claim that same clan. Anybody can come. My lord, the purpose of section 378, 372, these are two vexatious litigations, my lord. So where is the legal heir certificate, my lord? Then the question comes there. So I'll have my right to object to that also, my lord.
It is admitted that she is the sister of the victim, my lord.
Who has admitted? I have not admitted.
And on the last occasion, he himself said that she is the sister.
That is not the point. Yeah. What he says is that, you see, if you claim to be the legal heir,
That at least certificate has to be there.
it has to be.
Yes.
It has to be proved. No Tom, Dick, or Harry can come and
Yes,
before
yes.
this court. But as far as the 372 is concerned,
Yes, yes.
And in any case, as my brother has just pointed out, you have filed a miscase for
leave
leave
of
to
the
appeal.
court.
That miscase cannot be considered. It can be disposed of
My lord,
Yes.
my lord.
as not considered because it has no. It will have no effect on the.
My lord.
the
If it is under 372, it has no bearing.
that it has no effect on the appeal as such.
Yes.
So that settles the matter. Now only on the point of your bona fide.
Yes.
My lord, I am the legal heir, my lord. If necessary, my lord, I'll produce, my lord. I have not annexed it in the application, my lord, as a legal heir any certificate.
You produce that. So we'll dispose of this miscase as not press.
My lord.
My lord.
Miss Ardata, legal aid counsel, has submitted that through inadvertence, this miscase has been filed seeking leave of this court to appeal. However, it is submitted that this application is not pressed and may be disposed of as such. You've been made respondents here.
Yes, my lord.
Your respondent number,
Respondent number 1, my lord.
One, my lord.
Mr. Yubin, learned counsel, appears for the respondent number 1, and Mr. S. Sengupta, learned additional PP, appears for the state respondent number 2. On submission made by the learned legal aid counsel, this petition is hereby disposed as withdrawn. In appeal before this appeal is admitted, the learned legal aid counsel has submitted that the appeal has been preferred by the sister. Before this, not yet. Before this appeal is admitted and diarised, of the victim being aggrieved by the judgment and sentence, judgment and order dated
29/1/2025, my lord.
29/1/2025, wherein the accused person therein has been acquitted by the learned trial court. At this juncture, Mr. P. Yubin, learned counsel for the respondent, number 2, number 1.
One, my lord.
Respondent number 1 has raised an objection as to the locus of the appellant, inasmuch as there is no proof of her.
My lord.
Who's the appellant? Yes, there's no his, he,
She is the sister of the victim.
she or he.
She, my lord.
Here's there's no proof of her being the sister of the said victim. On this short point, this court is inclined to allow the Learned Legal Aid Counsel to produce proof in this regard as far as the locus of the appellant is concerned. How long?
2 weeks, my lord. But if I may submit, my lord,
My lord, may I just point out, my lord, if my lord,
Are you
if
saying that she is not the sister? Are you saying that the appellant is not the sister of the victim?
my lord,
Is it your stand?
my lord, I'm saying that let the legal heir certificate come, my lord. This is what I'm saying.
No, until unless you dispute it, why legal heir certificate is needed? If you dispute, she has made an assertion here
Yes,
in the appeal.
my lord,
She is the sister of the deceased.
my lord.
Now, if you say that that is not correct, then you have to say it. We'll record it.
My lord, that is what I'm saying, my lord. That's what I'm saying.
So
Let
you
let
say
the
you are
proof
disputing.
come.
You are disputing it.
Yes, my purpose of asking the certificate is to it's amounting to a disputing, my lord. My lord, besides that, my lord.
You
Yes,
dispute when
yes.
you have specific instruction. A lawyer doesn't stand here only to raise dispute for
My
the
lord,
sake of raising.
my lord,
Now,
absolutely. No,
if
no,
you
my
have a
lord.
clear-cut stand that she is not the sister, then you raise that dispute. We'll entertain.
My lord, I've raised an application of invoking section 378, my lord, where I'm saying that she is not a complainant, my lord. Now she is saying that no, then I will change to 372.
378 is gone.
It's gone. Now, my lord, in the what I wanted to point out to my lords is again, now the appeal stands 378, my lord. Even the memo of appeal, the appeal. So what I wanted to just assist my lord is that because that leave is not granted.
And your objection should be in that line, saying
Yes.
that
Yes.
no proof has been attached.
Yes.
Nothing.
So therefore, my lord,
Instead
at
of
least
disputing it, you
yes.
just say that
Yes.
that statement has not been supported by
Yes,
him.
yes. So these provisions, my lord, this needs to be changed also, my lord, because otherwise then it stands confused. Because in the memo of
lordship may
appeal.
allow me to correct it, my lord.
Yes, yes. Yeah. Thereafter, my lord, my other objections may come, my lord, like disputing to the bona fide or the status of the appellants, my lord.
You can do that. You see, the fact remains that this memo of appeal,
Yes, my lord.
firstly, is yet to be diarized.
Yes, yes.
So not yet. You see, not yet process.
Process, my lord. Yes.
Finally.
Yes.
Then, since no number has been given,
Yes.
so
Yes.
the appeal is not even put up for admission.
Yes, my lord.
So this is the stage where you are at liberty to do whatever you want.
Yes, yes, my lord.
Lordship may observe it, my lord. Lordship, the registry, they might not allow us to correct it, my lord.
Yeah, because now it's already on record, because it is what you can do is you can amend the cause title
Cost title, yes, yeah, my lord.
later. First, let us settle the issue of your locus. Then no, he said the provision is not there. He's filing now.
Or may I just assist, my lord? Otherwise, it becomes like this, my lord. Let him withdraw with a liberty to file it afresh with a proper invoking a proper provision, my lord.
Doesn't matter, but that's all right. At the end of the day, like I said, these are all technical issues which would not matter, because what is required would be the meat of the matter.
Yes, my lord. But this technicality, my lord,
No, that can be correct in due course.
Yes, it can be corrected.
I'm not
my
saying
lord.
it requires an elaborate process for that.
Yes, my lord. Yeah.
See, withdrawing this, filing a fresh one would entail.
Or just correction, my lord, with a liberty to correct.
That's what I said.
Yes, my lord.
She'll be given liberty to correct.
She's a
Go down,
legal
my lord.
counsel. At least
My
you
lord.
should have that thing, bear it in mind.
But she may be a legal aid counsel. I'm standing for my client who is been acquitted, my lord, of a heinous charges, my lord.
That merits will be looked.
My lord.
That was the
Go down, my
good
lord.
grounds for interference.
We'll go on to the last. On the prayer of the learned legal aid counsel to amend the cause title as far as the insertion of the proper provision of law is concerned. This too is allowed, provided the appeal is finally admitted.
My lord.
This is matter to 2 weeks.
My lord. Obliged.
Item number 3.
My lord, my brief has arrived, my lord. I am ready.
Start.
May it please, Your Lordship. Lordship, this appeal, it was raised against the judgment of the Land High Court, which was convicted under Section 302 IPC, and a sentence of life imprisonment was given to the 3 accused person. Lordship, if I may can take your Lordship to the
Yes.
The FIR,
Oh, sorry.
which is at page
Sorry, just a moment. Sorry. My brother's file is not Yes.
Lordship, if I may can take your Lordship to page 1, the FIR. And then the translated copy is at page 2 from the in the paper book. Lordship, if I may read. To the officer in charge, Umlong Police Beat House, Umlong. I beg to inform you that on the 16/11/1991, at around 4 p.m. at Lomkudung village, Shri Sadamuro, son of Unihan Suting, Lomkudung, has been murdered by 5 persons from the Lomkudung village by the name one Shri Tingen Muro, son of Ukyang Suting, Shri Luwit Muro, son of Ukyang Suting, Shri She Muro, son of Ukyang Suting, Shri Tri Muro, son of Ukyang Suting, and Shri Kamai Muro, son of Upil Dudan. The murderers were all from Lomkudung. Therefore, I request you to kindly look and investigate into the matter and to arrest the 5 persons named above. The witness who witnessed at the time of assault and murder of Sada Muro, Shri Dal Rangklam, and the father of Sada Muro has also been assaulted by these persons. Lordship, this FIR was filed on 16 November 1991, but as in the original FIR, it was the officer in charge. They received it on 18/11/91. That means after 2 days of the incident. Lordship, if I may can take.
Where is that? Where is the noting that they have received it on 6/18?
Lordship, if you can see the page number 1, the original FIR page 1 here, Lordship. If you can see down.
Okay.
Lordship, they filed it on 16 November. It was written there, but they have received it on 18/11. The officer in charge of Joe IPS.
Yes, Joe IPS, because it was filed before the Umulong.
Before the Umulong bid house.
And registered
So
subsequently.
from there, see, it may have taken some time for matter to be processed.
That is the regular way.
Nothing unusual.
Lordship, now if I may can take your Lordship to the evidence of PW1, which is at page number 27, and then the type copy, it's at page 33. May I read, your Lordship?
Why are you going directly to the evidence?
Lordship, the inquest report, it's at
What about statement under section 161, 164? Anything?
Lordship, after the evidence, it's in this matter, there's no statements, your Lordship, of 161 and 164 of the.
No statement. Nothing under 161, 164.
Lordship, 161, it's not there, your Lordship. 164 is there, of the headman of Madur, and
What about
there's no 161, your Lordship.
What about 164 of the accused person?
There's no 164 of the accused person also, your Lordship, in this matter. In this matter, your Lordship, it's very rare, because even the IO in this matter, your Lordship, has never examined. And then the eyewitness also, which was reflected in the original FIR, those 2 witnesses also, it's never examined.
Never.
Never, your Lordship. Lordship, if I can take you, Lordship, directly to the evidence.
So okay, let us be clear. These 2 eyewitnesses, which have been pointed out in the FIR.
In the FIR, yes.
And they have not been examined.
No, your Lordship, never. And then the IO in this matter also has never examined. Only the officer. Chief, if I may can take your lordship to the evidence of PW1, your lordship. Which
No
is
161, no 164.
164 is there, your lordship, of but it's not for the
No, but of the accused.
of the accused. It's not there, your lordship. Only 313 it's there for the all the three accused.
Okay.
Lordship, the evidence of PW1, your lordship, it's at page 27. Lordship, and then the type copy it's at page 33, your lordship. Lordship, may I read, your lordship? Lordship, may I read?
This one. Where is the original of this?
It's at page 27, your lordship. Page 27. The type copy, it's at page 33.
Okay. PW1.
PW1, yes, your lordship.
Yes.
I know all the accused persons who are present in the court today. One Sadam Muro, who is now dead, was my younger brother, who died on 16/11/1991. He was murdered by all the above accused persons. I saw the occurrence myself. The occurrence took place around 6:30 p.m. to 7 p.m. on the said date at the paddy field belonging to my mother, Kakwen Muro at Lumkudong. Immediately after the incident, I asked them as to why they killed my younger brother, who was not mentally sound. I further asked them why they did not inform me and my family before killing him, and to which they replied that they had already informed my family members, which is in fact not true, which is in fact was not true. I do not know the reason why they killed my younger brother. The cross, your lordship. I was at my place of work from the 13/11/1991 to 16/11/1991 at Sungwali, where I make harvest of my paddy. I reached home on 16/11/1991 at around 6 p.m. The paddy of my mother is at Lomkudung village, and me at Sung and met at Sung Valley. From Sung Valley, I reached my house first, then the paddy field of my mother. On reaching home, I took my meal and get ready for bed. Then at that point of time, the accused came and dragged my younger brother to the paddy field of my mother. At that time, my brother Usada Muro, Ukaya Muro, Kakuen Muro, Unihan Suting were also present at home. Then we did nothing to follow the accused along with our brother Usada Muro and asked them not to beat him. The distance of the paddy field from our home was about 100 meters. The time when they dragged him from our house is just before 7 p.m. During the dragging process, the accused person also manhandled my brother Upaya Muro. My father also Unihan Suting was assaulted by the accused. We did not inform the headman about the incident on the said date and time, but have however made hue and cry, to which none came to the rescue. It is a fact that my brother Usada Muro was left in the paddy field on 16/11/1991 till 18/11/1991. On being queries as to why she did not take her brother Usada Muro to her home immediately. She replied that her religious practice in Anyam 3 it's not permissible to carry home. I think, Your Lordship, in their case, to carry home a case of a person. I think in case of a person who met with an unnatural death. It is a fact that my brother Ukaya Muro reported the matter to the headman of Lomkudung on 18/11/1991, and thereafter a complaint was lodged with the police. I stated that the FIR lodged by my brother is wrong to the extent that I am an eyewitness. Lordship, if I may can pause here, Your Lordship, that as per the judgment and order of the Land Trial Court, it was corroborated that PW1 also, she's one of the eyewitness. But if I may can take, Your Lordship, if we can see in this in the evidence by herself, it was stated that I am an eyewitness. But in the FIR, she's not the it's not reflected her name as an eyewitness. Lordship, I do not know who attacked first the deceased. I was at a distance of about 3 to 4 meters from the place of occurrence. During this winter season, on that particular night, it was still visible to the naked eyes through the time was though the time was 6:30 to 7 p.m. at night. It was not at all examined by the police. The police examined only my mother Kakwen Muro and my sister Kasole Muro on the 18/11/1991. Subsequently, I was examined by the police and I have told them that the incident took place at 4 p.m. My statement before the police about the time is uneven, and my time before the court about the timing of the occurrence is correct. It is a fact that I never stated before the police that the accused person dragged my brother Usada Muro from our residence on the alleged date of occurrence. It is a fact also that I never stated before the police that my brother Ukaya Muro and my father was assaulted and manhandled by the accused persons. It is a fact that my deceased brother was a lunatic. It is a fact that my brother is hospitalized and is in mental jail Shillong. It is a fact that my deceased brother was a criminal lunatic. It is a fact that only when he was provoked that he became violent. I do not know if my deceased brother destroyed the rib body of the accused. It is not a fact that my brother was not dragged from home on this date and time of occurrence. It is not a fact that my brother and the accused were also in the party field prior to the time of occurrence as stated by me. It is a fact that my deceased brother created troubles, and on time and occasion the Dorbarsham directed us to hand over to the police, and thereafter they sent him to mental jail Shillong. I was not present on the 18/11/1991 when the police came to inquire into the death of my brother. I do not remember at what time the police arrived at the party of my mother on 18/11/1991. I arrived at the paddy field of my mother at about 8 p.m. on 18/11/1991. I was at home on 16/11/1991 at 6:30 p.m. I went to report the matters to the police on 17/11/1991. My brother was not taken to hospital for post-mortem. Lordship, if I may can take you, Lordship, to PW2. This is the officer of the Umulong Bid House. Page 37, Your Lordship.
See what? Firstly, what is your what is your observation or contention as far as the evidence of PW1 is
PW1,
concerned?
Lordship. Lordship, as far as the corroborations which was made by the learned trial judge in the which was Lordship, I'll come after that when because the corroboration of PW3 also it's because the evidence of PW3 also, so that I can show you, Lordship.
Okay.
Lordship, if I can take you, Lordship, to page 37, deposition of Shri William Muksor. Lordship, if I may read, Lordship. I received someone to appear and depose before the court today. In the year 1991, I was posted at Umulong Bit House as the in charge. The instant case was investigated by SIQE Pala, and on his transfer, I was directed by the then SP Jawai to file charge sheet in connection with this case, charge sheet number 37, 1994, dated 14/04/1994 under section 302/34 IPC. I do not know the accused person in this case. Lordship, if we can take Lordship, he is not the IO in this matter. He is just the officer which was directed by the SP Jawai to file the charge sheet. I think Lordship, in this matter, he has no role in this matter. Lordship, if I may can take you, Lordship, to PW3, Shri Kayamuro, he is the brother of the accused. He is the brother of the victim and the brother of the PW1. Lordship, I received someone on to appear and depose before the court today. I know the instant case as the this is victim Shri Sadamuro was my brother. I cannot remember the date, month and year of the incident. On the day of the incident, I was at home along with my parents and my deceased brother. At around 6 p.m, Kwan Shri Dal Rangklem came to our house, and after some time, he left our house. Thereafter, my victim brother went out of the house, and I saw 5 persons chasing my brothers and catch him at the paddy field and started assaulting him. On seeing my brother being assaulted, I along with my parents rushed to the paddy field to stop those 5 people, but they still continue assaulting till he died on the spot. I know the 5 persons who have assaulted my brother, and their name are Tngen Muro, Sne Muro, Tene Muro, Kamai Muro, and Luwit Muro. All belong to Longkudong village. Today, only accused Shri Sne Muro, Tene Muro, and Tngen Muro are present in the court dock. All the accused persons are my cousin brothers. After assaulting my brother, all the accused persons fled away from the PO. I, along with my elder sister, Yong Muro, went to Umulong Bit House to report the matters to the police, and the FIR was typed by someone whose name I cannot remember now, and I have signed in the FIR. Exhibit 1 is the FIR, and Exhibit 1 by 1 is my signature. The dead body was guarded till the arrival of the police after 2 days of the incident. The police did some inquiry at the PO. I do not remember now if the doctors also came to the PO. Later, the dead body was handed over to us for conducting the last rites. Later, all the 5 accused persons were arrested by the police. This is the cross by the defense counsel. It is a fact that I have informed the police about the incident at about 8 p.m. It is a fact that whatever I have deposed before before the court today is true and correct, and the statement before the police that I was informed by somebody about the incident is not correct. It is a fact that me and my other 4 family members just stood at the PO requesting the accused not to assault the victim, but we did not do anything as we are all scared. It is a fact that only we, the family members, witnessed the incident at the PO, and none of the villagers saw it. At the PO, it was me, my father, mother, and two sisters, namely Yong Muro and Dina Muro, were present. The dead body of the deceased victim were also lying at the PO for 2 days from the date of incident. I saw that all the 5 accused persons together assaulted my victim brothers. I had informed the police about the incident at Umulong Bit House. Lordship, if I can take your lordship to the evidence of PW1. Lordship, if we in the PW1, she stated that her brother was dragged from the house, and then if we can say that the what PW3 said, your lordship, PW3 said that he was chasing by the accused person. There's no corroboration, your lordship, in this matter, because chasing and dragging, it's totally a different meaning, your lordship. Lordship, if I can take your lordship to page number 40, PW4. This is the evidence of the doctors. Lordship, may I read, lordship?
Yes.
I received someone to appear and depose before this court today via VC, as I am not in good health and is not in a position to personally appear before the court. I joined service in the year 1980 and was posted at Umulong Dispensary. In the year 1991, I was posted at Jawai Civil Hospital. I received a requisition from the police to conduct the post-mortem on the dead body of Shri Sadamuro, male, aged 23 years, at the spot/place of occurrence, which is the paddy field of the deceased mother Quen Muro. The examination was conducted on 18/11/1991 at 2 p.m. Lordship, this is the details: the thorax, walls, ribs, and cartilage. It's healthy. Pleural healthy. Larynx and teres, right lungs, left lung healthy. Pericardiums healthy. Heart healthy. Vessel healthy. This is the muscles, bones, and joints. Injury nil. Disease or deformity nil. Fractures nil. Dislocation nil. External appearance, condition of the subject normal. Wounds, position, size, and character normal. Bruises, position, size, and nature nil. Mark of ligature on neck, desertion extra nil. Lordship, abdomen, wall, pituitarium, mouth, pharynx, and esophagus, stomach and its contents, small intestine and its contents, large intestines and its contents, liver, spleen, kidneys, bladders, organs of generation, external and internal healthy. External appearance, lordship, skull, skull, vertebrae. The head it's broken. Membrano ruptures. Brain and spinal curves. Exutubes. After examination of the body, I found the opinions of the doctors. The head is broken, the membranes ruptures, lacerated injury on the chin, and the chin is broken. Lower lip disfigure, incised wound on the left temporal region, measuring 3 into 2 centimeters. Upper jaws and 6 teeth broken. In my opinion, the cause of death was due to hemorrhage resulting from the above injuries. Lordship. I have also prepared a report after the postmortem examination was observed. Exhibit 2 is the postmortem examination report, and Exhibit 2/1 is my signature. Lordship, in this matter, the cross was declined. Lordship, if I may can take your Lordship to the examination of accused person.
Yes.
Lordship, if I can take you Lordship to the 313 examination of accused person, Lordship. Lordship, which is at page 43.
Yes.
Lordship, number 1. This is Shri Sne Muro, Lordship. PW1 Srimati Mandu Muro stated in his evidence that I know all the accused persons who are present in court today. One Sada Muro, who is now deceased, was my younger brother who died on 16/11/1991. He was murdered by all the above accused persons. I saw the occurrence myself. The occurrence took place at around 6:30 to 7 p.m. on the said date at the paddy field belonging to my mother Kakuen Muro at Lumkudung. Immediately after the incident, I asked them as to why they killed my younger, who was not mentally sound. I further asked them why they did not inform me and my family before killing him, and to which they replied that they had already informed my family members, which in fact was not true. I do not know the reason why they killed my younger brother. What do you have to say? I did not kill Saddam Muro. And then PW2 Sri Willie Muksor stated in his evidence that in the year 1991 he was posted at Umulang Pit House as in charge. The instant case was investigated by SIQE Pala, and on his transfer, PW2 was directed by the then SP Jawai to file charge sheet in connection with this case charge sheet number 3794 dated 14/04/1994 under section 302 34 IPC. What do you have to say? I do not have anything to say on the above evidence. PW3 Sri Kayamuro stated in his evidence that he know the instant case as the accused as the deceased victim Sri Sadamuro was his brother. I cannot remember the date, month and year of the incident. On the day of the incident, I was at home along with my parents and my deceased brother. At around 6 p.m. one Sri Dal Rangklem came to our house, and after some time he left our house. Thereafter, my victim brother went out of the house, and I saw 5 persons chasing my brother and catch him at the paddy field and started assaulting him. On seeing my brother being assaulted, I along with my parents rushed to the paddy field to stop those 5 people, but they still continue assaulting till he died on the spot. I know the 5 persons who have assaulted my brother, and their names are Tngen Muro, Shne Muro, Tene Muro, Kamai Muro, and Lomit Muro. All belong to Lomkudung village. Today, only accused Sri Sne Muro, Tene Muro, and Tengen Muro are present in the court dock. All the accused persons are my cousin brothers. After assaulting my brother, all the accused persons fled away from the PO. I, along with my elder sister Yong Muro, went to Umlongbit house to report the matters to the police, and the FIR was typed by someone whose name I cannot remember now, and I have signed in the FIR. Exhibit 1 is the FIR, and Exhibit 1 by 1 is my signature. The dead body was guarded till the arrival of the police after 2 days of the incident. The police did some inquiry at the PO. I do not remember now if the doctor also came to the PO. Later, the dead body was handed over to us for conducting the last rites. Later, all the 5 accused persons were arrested by the police. What do you have to say? I don't have anything to say on the above evidence. PW3 belongs to same clans to which I belong. For Dr. Poida Tubru stated in his evidence that in the year 1991 I was posted at Jowai Civil Hospital. I received a requisition from the police to conduct the post-mortem on the dead body of Shri Sada Muro, male aged 23 years, at the spot place of occurrence, which is the paddy field of the deceased mother Kwen Muro. The examination was conducted on 18/11/1991 at 2 p.m. Thorax, wall, ribs, and cartilage, pleura, larynx, and tracheas. Right lungs, left lung, pericardiums, heart vessels healthy, muscle, bones, and joint injury, disease, or deformity, fracture, dislocation nil. External appearance condition of the subject: wounds, bruises, mark of ligature on neck, dissection, etc. normal. Abdomen, walls, peritoneums, mouth, thorax, and esophagus, stomach and its contents, small intestine and its content, large intestines and its content, liver, spleens, kidney, bladders, organs of generation, external and internal healthy. External appearance: skull, vertebrae, the head it's broken, membrane rupture, brain and spinal cord issutus. After examination of the dead body, I found the head is broken, the membrane ruptures, lacerated injury on the chin, and the chin is broken. Lower lips disfigure, incised wound on the left supratemporal region measuring 3 into 2 centimeters. Upper jaws and 6 teeth broken. In the opinion of PW4, the cause of death was due to hemorrhage resulting from the above injuries. PW4 had also prepared a report after the post-mortem examination was observed. Exhibit 2 is the post-mortem examination report, and Exhibit 2 by 1 is the signature of PW4. What do you have to say? I do not have anything to say on the above evidence. Lordship, if I may can take your lordship to the evidence of PW4, your lordship, the cause of the death. Lordship, in this matter there is no instrument. The materials also it's not seized. Why? What is the cause of the death? That lordship, if you can see that the incised wound on the supra, that once it's we cannot say what type of incised wound also, your lordship, but in this matter, your lordship, there's no materials which was seized by the IO, and then they have never exhibit that one also, your lordship. Do you have to, lordship, point number 5, do you have anything more to say? No. Will you adduce evidence in your defense? No. Lordship, if I may can take, lordship. Lordship, Tengen Muro. Page number 48, your lordship. This is the...
Yes.
Lordship, this I think more or less is the same only, your lordship. Yes. Same only, so I don't think so, Lordship. I may can take your Lordship. Lordship, I'll take you. Lordship, I'll come directly to page 58. This is the statements on the 164. 164 of the headman, your Lordship. Headman of Madur village. Lordship, may I read, Lordship?
This is only a certificate of the.
Yes, your Lordship, to prove that the witness died. Lordship, I'll read, your Lordship.
Not necessary.
Lordship will same only page 59 also, your Lordship. This one is the 164 of Ebi Muro. This is to show that the Shri Dal Muro, which is her father, is died on 7/05/2006. And then next, Lordship, page 60 also 164 of Srimati Emily Muro. This also to show that the expire of Shri Nihon Suting, who is a father, which was expired on in the year 2018.
Srimati Emily Muro.
Emily Muro.
In page 69, she says, "Sri Dal Trunklam is my father. He expired on so and so."
Yes, your Lordship.
Here also says Nihon Shooting is my father.
Yes, this is the one. It's MB, Lordship. Page 59. It's MB Muro, and then 60. It's Emily.
Oh, Emily.
Emily Muro, Lordship. Lordship, I'll take Lordship directly to the Lordship. There's a sketch, rough sketch map, Lordship, which is at page. Which is at page 97, your Lordship. The rough sketch map, which at the place of the resident, your Lordship.
Yes.
Lordship, now I'll come to the judgment and order of the learned trial court, your Lordship, which is at page 98. Lordship, if then page 99, it's the operative part, your Lordship. This is the judgment. Lordship, may I read, your Lordship? The criminal proceeding in the instant case was set in motion.
You don't have to read the whole judgment. You just point out to the court, as far as this judgment is concerned, which portion of the findings or observation you are contentious about.
Yes, Your Lordship.
And what are your grounds for such contention?
Lordship, if I may read the paragraph number 3, Your Lordship, in this.
3.
The order sheet reveals, which is at page
100,
Your Lordship.
Yes.
The order sheet reveals that 5 named accused person in the FIR was arrested on 19/11/1991 and released on bail by order dated 03/12/1991. The IO found the dead body of Sada Muro on 18 in a decomposed state Postmortem was conducted at the PO. The investigation culminated into a charge sheet being charge sheet number 37.
Where is the inquest report?
The inquest report, Your Lordship. The inquest report, which is at 87, Your Lordship.
87?
Yes, Your Lordship. Then the type copy, it's at page 88, Your Lordship. Lordship, I, SIQE Pala, in charge Umlong Bid House, do hereby today, the 18th November 1991, at 3:10 p.m. hold inquest over the dead body of Sri Sadam Rose, son of Nihon Suting of Lom Kudung, at the paddy field of his mother Gwen Muro. On being identified by his younger sister Srimati Yoka Muro, in presence of the following witness, in connection with Jawai PS case number 166/1991 under section 302/34 IPC. The dead body is lying with the head toward the east and legs portion to the west and the face upwards. His age is about 23 years old. He is wearing with green shirts and black trousers and barefooted. On checking the injuries, I found his head is broken and brain came out. About 4 to 5 feet broken and jaws lower and upper crushed. Further on the left side of head, incised wounds appear in the different size and shape, which seem smashed by sharp object checked thoroughly on the whole of his body, found no more injuries. Lordship, if I can pause here, Your Lordship, that there's in the inquest reports which was says that it was smashed by sharp object, Your Lordship, but there's no instruments which we can show, Your Lordship, that the cause of the death it's by any instrument, Your Lordship. The dead body it's forwarded to the medical and health officer in charge Umulong PHC for holding spot postmortem examination and opinion to ascertain the cause of death. Lordship, so if I may take you, Lordship, to the judgment, to the impugned judgment and order.
Yes.
Lordship, at page 100, paragraph number 3. Lordship, I may read it, Lordship. The order sheet revealed that 5 named accused person in the FIR were arrested on 19/11/1991 and released on bail by order dated 03. The IO found the dead body of Sadomuro on 18/11/1991 in decomposed state. Postmortem was conducted at the PO. The investigation culminated into a charge sheet being charge sheet number 37/1994, dated 14/05/1994 under section 302/34 IPC against all the 5 named accused person. The IO, relying on the statement of 10 witnesses, filed the charge sheet. It is pertinent to mention that the charge sheet was filed before the additional Deputy Commissioner Jawai before the, that means before the separations of the judiciary from the executive, your lordship. Then after filing charge sheet on 1st 3/1995, copies were served to the accused person in compliance with section 207 of CRPC. Charge was framed against all the 5 accused person on 22nd 05/1995. The 5 accused person pleaded not guilty and demanded for trial. The accused Kamai Muro died during the course of trial on 18/08/2018, and he was declared dead. White order dated 14/02/2020. The accused Lowit Muro reportedly died during the course of trial. However, there's nothing on record showing that Lowit Muro has been declared dead. The trial proceeded against the accused Tengen Muro, Shne Muro, and Tene Muro. From the record, it emerged that after framing of charge on 22nd 05/1995, the matter was posted for evidence till 31/05/2005. For 10 years, no witnesses were examined. Thereafter, on 11/07/2005, the case was transferred to Fast Track Court, Jawai, for disposal, and the matter was posted for evidence before the Fast Track Court. The Land Fast Track Court White Order dated 17/03/2010 has observed that the matter was posted for evidence for 10 years. No witnesses has been examined due to the non-appearance of the accused. The matter was again posted for evidence. No witnesses were examined. After the separation of judiciary from executive in the district of West Jaintia Hills District, Jawai, the case was transferred to this court on 17/09/2015. This court White Order dated 29/10/2015 posted the matters for evidence, and appearance of the accused learned counsel Shri S. Chakraborty was appointed as stated defense counsels. White Order dated 12/1/2016 to represent the 4 accused persons. Lordship, I'll come directly to the I'll come to paragraph number 5, Lordship. Lordship, in paragraph number 4, it was, Lordship, if I read this paragraph number 4 also, Your Lordship, in this paragraph it was reflected that QE, that the IO in this matter, Your Lordship, died on 6/11/2022, Your Lordship. Lordship, in paragraph number 5, Your Lordship, the prosecution during the course of trial examined only 4 witnesses. Thereafter, the 3 accused persons were examined under section 313 CRPC on 22nd 06/2023. The accused persons were given an opportunity to bring defense witnesses. They declined to bring defense witnesses. As such, the matter proceeded for final hearing. Lordship, in this matter, the main corroboration it's in this matter, Lordship, it's only the PW1 and PW2. Based on their evidence, Your Lordship, the learned trial court convict all the 3 accused, Your Lordship. Lordship, I'll come directly to the prosecution arguments, Your Lordship, which is paragraph 7, Your Lordship. Lordship, if I may read, Your Lordship.
Yes.
Learn additional PP submit that the evidence of PW1, brother of the deceased Saddam Muro, clearly revealed that he was present and he saw the 3 accused had murdered his younger brother Saddam Muro in the paddy field, and he is the eyewitness to the incident, Your Lordship. If I can pause here, Your Lordship. In the Lordship, in the FIR itself, here's the name of PW1. It's not reflected as the eyewitness. What was reflected, it's a different name, and then those 2 witnesses who are the eyewitness has never examined in this case, Your Lordship. And then the incident of the evidence of PW1 corroborated with the evidence of PW3 Kaya Muro, who is also the brother of the deceased Sada Muro. PW3 also saw the 5 accused, took his younger brother Sada Muro to the paddy field and assaulted him. The evidence of the doctor corroborated with the evidence of PW1 and PW3. The postmortem report clearly revealed that the death was caused due to hemorrhage from the injuries. The prosecutor fairly admit that vital witness could not be examined during the trial as they expire. However, with the evidence on record, the prosecution has clearly established that the accused person named in the FIR had assaulted Sada Muro, causing bodily injury resulting in death of Sada Muro. As such, the prosecution has established the charge beyond reasonable doubt and pray for conviction of the 3 accused persons under section 302. Lordship, in this matter, in the charge sheet itself, Lordship, there are 10 witnesses, but in the trials, there's only 4 witnesses which was
This is expired, my lord. If they want, they may have also different. I'm not their advisor, my lord. What they have to do, they should explore that. But this order has expired, my lord. Law section 163 is very clear. So, my lord, I only want an observation from this honorable court that in view of provision of section 163, the order is expired, my lord, and nothing survives in this writ petition.
Yes, I see, Mr. Shulai.
Lordship, kindly have page 20, Your Lordship. That is the so-called order of appointment of authorized agent, Your Lordship. If Lordship kindly have clause 6, page 20, clause 6.
Yes.
Lordship, kindly see that wherever necessary checkpoint, station come office may be set up on convenient area as may be agreed upon, provided that such checking shall not be on the national highway, state highway, PWD roads. This is the condition, Your Lordship. The case is on the highway, national highway, Your Lordship. There is no permission from the National Highway Authority of India, Your Lordship.
See,
And under the National Highway Authority, Your Lordship, there is permission is required, Your Lordship.
See, Mr. Shulai, you are enlarging the issue, which is not at all relevant. Number one, as far as the impugn order is concerned, this impugn order is simply an order passed by
under 144. That is the admitted fact, Your Lordship.
144.
And
now that in the eyes of law, that order has since become obsolete, redundant, cannot be. Rather, it has done its wrong. Put it that way. Now, the order has become useless for all practical
Lordship,
purposes.
kindly see. Lordship,
See,
kindly
no, we are
appreciate.
confining only to what has been agitated in this petition. If the import of this order has been challenged in this petition, when there's nothing else to decide, matter ends there. If you have any other grievance apart from that, as far as your contention is concerned, setting up of toll gates and national highways, so on and so forth, that is another another issue to be raised altogether. In
Lordship, kindly see the impugn order, Your Lordship. It must have passed, Your Lordship. Kindly see what is the impugn order, Your Lordship. Kindly have again page 54, Your Lordship.
Yeah. Yes.
Lordship, kindly 1, 2, 3, 4, 5, 6. Lordship, kindly paragraph 6 from the bottom. Whereas as per letter from the government number so and so, check gate, toll gate on national highway and major district cannot operate without the requisite permission from the Ministry of Road Transport and Highways and the state government.
See, whatever is there, whatever is here in this paper, you tell me what is the validity of the authority of this of this paper.
But Lordship, kindly see, this order must have passed. It must have expired, Lordship. But the issue, Your Lordship, the issue of setting up tollgate on the national highway, that too without prior permission of the National Highway Authority of India, Your Lordship.
Yes, that is, see, that remains. That remains there.
And
there
in
is no,
pursuance, Lordship, and in pursuance to this order, Your Lordship, the tollgate has already been closed down, Your
whatever
Lordship.
the case may be, yes, it may have been closed down. So
Closed
matter,
down, Your Lordship.
matter ends there.
The
If,
matter,
let's put it this way: if they now, you see, after this case is disposed of, set up the same checkpost or same toll gate, whatever you are at liberty to take.
then if Lordship make that observation, then that would suffice, Your
In
Lordship.
accordance with law, they are
Then
always
the
at liberty.
Lordship will make that observation, Your Lordship.
Heard learned counsel for the parties. Dr. N. Musica, learned senior counsel, appearing for the petitioner, has submitted that the main grievance of the petitioner, for which this court has been approached, is the issuance of the respondent. Deceased respondent.
4.
Issuance of the respondent number 3, isn't it? 3 or 4?
3 and 4. District Deputy Commissioner, District Magistrate. 3/4, my lord. They're both.
But why same person?
Person is same, but Deputy Commissioner is different.
No, power has been exercised as
As the District Magistrate. Number 4, my lord.
Magistrate.
Number 4.
Respondent 4. Okay. Number 4 of the order under section 163 BNSS.
One 163/4, my lord. There's nothing.
Stop. It is also the order submission of the learned senior counsel that this order, the impugn order, has been passed on
4th February.
4th
February 25.
4th February 2025. Referring to the provision of 163, subsection 4, the learned senior counsel has pointed out that the order, that any order passed under this section shall remain in force only for a period of 2 months. Accordingly, since the said period of 2 months has already expired, therefore the impact of the order in question has no value at this point of time. The same has become redundant. It is therefore prayed that this petition will be disposed of by a suitable observation by this court. Mr. Ndishulai, Learned AG, in response, Learned AG, appearing for the state respondent, in response, has submitted that admittedly the said impugn order has done its course. However, the issue, or rather the course of action for which the said impugn notification has been issued, still remains, inasmuch as the issue involved operation of toll gates on national highways and major district roads, which operation has been restricted to prior or due permission from the Ministry of Road Transport and Highway, and any operation of such toll gate without due permission cannot be allowed by the district authorities. The Learned AG would therefore maintain that accordingly, in the light of accordingly, since the petitioner has not pressed for hearing of this petition on merits, on such ground, the petition is hereby disposed of as
infructuous.
As such. In parting, on the submission of the Learned AG, it is open to the authorities concerned to take necessary action in accordance with law as and when required in case of violation by any person, as far as the issue of operation or erection of toll gates on national highway and major district roads are concerned.
One observation, my lord. We have pleaded it is not on national highway, my lord. It is away from national highway. They'll take advantage of that, my lord. Your lordship has given so much of liberty to them, my lord. Tomorrow itself they'll come and close it. But they have to follow the law, my lord.
No, the fact remains that, you see, this is the impure order.
My lord.
It has got no sting.
My lord. But till there is okay, but the liberty your lordship is given that they are at liberty to take action, any action.
If any action is
I pointed out.
In case of any violation, my lord.
On national highway, on national highway and district major district, that is there.
And state PWD road, your lordship.
In case of any violation.
In case of any violation.
My lord, that observation, my lord. In case of any violation.
In case of the last portion. Is concerned. Violation is there.
Of law, your lordship.
Deep.